Good day. I'm Jeff Clayton. I'm the Executive Director of the American Bail Coalition. Thanks for taking the time to watch our series, 2021, an update on bail reform. In this Module 1, we look at the issue of whether cash bail or money bail is unconstitutional, which is a typical talking point we hear from around the country. Let's learn what these cases mean, and let's learn how not only is bail constitutional, but there is a fundamental constitutional right to bail still standing at the end of these cases. And so we begin. The meaning of the federal bail cases from Varden to O'Donnell. We start 6 years ago this January, in January of 2015, when a woman by the name of Christy Varden unfortunately stole from Walmart, was arrested in the parking lot, and allegedly could not afford to post a $200 bail set then by a bail schedule. A bail schedule is a schedule of bails based on the crime that was in effect in the city of Clanton, Alabama, where Ms. Varden stole from Walmart. The Civil Rights Corps, which is a litigation outfit, nonprofit, which was then called Equal Justice Under Law, which is a Washington-based nonprofit, sued the city of Clanton, Alabama on behalf of Ms. Varden, alleging violations of the Due Process Clause, both substantive and procedural, and the Equal Protection Clause, insofar as Ms. Varden was facing discrimination based on her economic status. And in so filing this case, these attorneys created this right to be free from wealth-based discrimination, as they called it. What happened then? U.S. Attorney General Eric Holder filed a statement of interest in the Varden case on behalf of the United States Department of Justice in January 2015, supporting this concept that there should be this right to affordable bail and that Ms. Varden should be released from jail due to her indigency. Ultimately, what happened? The city of Clanton settled the case, agreeing that all persons should be heard on bail by a judge within 48 hours of being arrested and having not posted bond. But interestingly, the standing order did allow for the continuation of a bail schedule so that people could get out of jail prior to seeing a judge in the city of Clanton. And so in other words, the first case, the biggest shot fired across the bow, settled, leaving a bail schedule and monetary bail still in place, although with better procedures. And it's important to point out that in the city of Clanton at the time, arrestees who were unable to post bail on a bail schedule could sit there for as long as several weeks prior to seeing a judge. And that was the big problem in that case. Of course, after that, this triggered a wave of litigation, primarily in the South, against bail schedules. And these included a lot of small cities like Moss Point, Mississippi, Ascension Parish, Louisiana, Dothan, Alabama, the city of Dodge City, Kansas. And I would argue that many of the settlements, in fact, most of the settlements were very similar to those in the city of Clanton case. And the key issue in all the cases was simply that there was no consideration of indigency or alternatives to bail within 48 hours or any reasonable time frame, and thus the bail schedule was largely determinative. What we also saw in those cases was a situation where the judges, when they heard somebody, would still defer to a bail schedule, which meant that there was no meaningful consideration. And in some of the cases, we saw that as well, where defendants were heard within 48 hours, but had no right to meaningfully argue their bail. And as I said, nearly all of the cases have settled using the new standing order that was issued in the Clanton, Alabama case, which later formed the basis for the 11th Circuit's decision that we'll see in just a moment. At that point in time, the Civil Rights Corps got more aggressive. They tried to push the envelope further, this time arguing that no one may be held in jail on a bail they cannot afford, regardless if set by a judge or by a bond schedule. In other words, there is a right to be free if you don't have the money. In other words, there can be no sub rosa detention, which we discuss in a later module. And so they began to sue bigger jurisdictions like Harris County, Texas. They got lucky in the Harris County, Texas case and the Walker versus Calhoun, Georgia case by getting federal judges to affirm this absolute right to be free from wealth-based discrimination, which equates to a right to free release, sometimes termed the right to an affordable bail. In other words, if a bail is imposed and you can't afford it, you get out of jail anyway. And they got federal judges to agree with that. In the intervening couple of years during the 2018-2019 period, both the 5th and the 11th Circuits reversed both judges Rosenthal and Murphy on these points. And joining in the brief, it's important to point out, was that the U.S. Department of Justice joined the brief, as did 11 state attorneys general, arguing that there is no right to an affordable bail. And ultimately, what happened? The heart of both opinions was that there was no right to an affordable bail. Of the right to an affordable bail, the Fifth Circuit said no such right is in view. There is, however, a substantive due process right to be free from discrimination during this time period. In other words, there is a right to have your bail reconsidered. If not, it violates the substantive due process clause. And I think that was clear in these cases, that it can't go on forever, that there is a right for indigent parties to be heard by a judge within a prompt time frame after an arrest, typically within 48 hours. And so there is a right. It's important to point out there is a substantive due process right, but the remedy to that is procedural. And we'll talk about what the Fifth Circuit did in just a second. The Fifth Circuit laid out a model injunction containing a model bail policy that will pass constitutional muster. And we encourage you all to take a look at it. In fact, we've drawn up a model bail policy based on the injunction that could be implemented to avoid the possibility of litigation. And as we said, I mean, and is that judges, when they set bail, they cannot defer to a bail schedule when that happens. And that is where jurisdiction could get into trouble by continuing to have a bail schedule, but then over deferring to it and making it dispositive. Use it for what it is, which is a temporary bail that will allow somebody to bail on a schedule to get out of jail prior to seeing a judge to make the system more efficient, to then devote scarce resources to the cases that need to be heard because they can't afford bail and they need consideration of alternatives. So the issue remains and always has been bail schedules, balancing the right to prompt release with scarce judicial resources. And if all bails were set in open court with meaningful consideration of indigency and bail alternatives, the system would never run afoul of the due process or equal protection clauses. And for most jurisdictions, that would be impossible to do. For example, in Los Angeles County, of those who will post bail, 70% will do so based on the bail set by the schedule without having seen a judge. And so the judges would have to set all those bails where people are bailing on the schedule, which could mean more jail for all if everybody's got to be heard and we can kick this time deadline out for 48 hours for everybody arrested. So it could be more jail for all. The Fifth Circuit last month in December 2020 held that there's no right to an affordable bail in this Dallas County case, again, pointing to the model injunction in O'Donnell as the solution to the indigency bail problem, and said in the opinion that the Civil Rights Court and these plaintiffs want more than the remedy that was offered in O'Donnell, which was procedural. There is a substantive due process right to be free from discrimination, but the remedy is procedural. You get a hearing, you get a real hearing with an attorney in the room to argue that you get bail alternatives, and that's the remedy. There's only two jurisdictions where bail schedules were held unconstitutional. One was in the Northern District of California in the Buffin versus San Francisco case, where the judge applied the strict scrutiny test and all state and local officials abandoned the defense of the case. And there's a pending case in the 11th Circuit where a court specifically applied rational basis and found that there's no rational basis for the bail schedule. But both the 5th and the 11th Circuits, the only two courts of appeal to hear this, refused to apply the strict scrutiny test, with the 11th Circuit applying the rational basis test and the 5th Circuit applying heightened scrutiny, approaching intermediate scrutiny to these questions of substantive due process violations. In other words, bails at the end of the day that are not excessive may serve to detain a person pending trial after a judge has considered indigency and alternatives to bail. And like I said, the only exception to this that we'll learn in the other module, what this means, is what the Nevada Supreme Court did in interpreting federal law. And we can talk about that's a little evidentiary wrinkle. But by and large, bails that are not excessive may continue to serve to detain a person. There is no absolute right to release due to indigency or any other factors. It's the continuation of setting of bail under the standards, the constitutional standards, that continues to govern at the end of the day after 6 years of litigation. Talk briefly just about the Harris County, Texas case, the O'Donnell case. I mean, I think it's important to point out that Harris County and the newly elected judges abandoned the defense of the misdemeanor case and imposed a standing order that in effect operates a no money bail system by creating a right to an affordable bail, but then allowing a judge to impose a quote unaffordable bail in some class of cases, what they hoped would be 15%, that would then serve to detain a person. And there was no doubt about it. They were doing that directly, saying that we are doing it with the direct purpose to detain. And I think it's questionable whether this is constitutional to intentionally impose monetary bail with the specific intent to detain rather than following the mandates of Stack versus Boyle and other U.S. Supreme Court precedent that says that bail has to be reasonably set at a figure reasonably calculated to meet the purposes of bail and no higher. And obviously, we've seen all kinds of problems in Houston as a result of the changes in these bail policies. You know, cleaning up the system of post-arrest due process, we think is simple. We think it'll avoid litigation. We think it'll allow jurisdictions to respect the constitutional right to bail and balancing the need to ensure public safety and guaranteeing court appearances. And at the end of the day, what this was about was taking the system of bail more seriously, to realize that when somebody is in jail, we are denying their constitutional right to liberty. And we need to get our act together when we actually put somebody in jail to make sure that they are heard in a timely fashion and that they don't languish in jail. And so after 6 years of litigation, you know, I think this has turned out to be a fairly positive result. If you have questions or comments, definitely reach out to us at our website, ambailcoalition.com, or send me an email at jclayton@americanbail.org. To close, I think, you know, we've learned that there is a substantive due process right to be free from wealth-based discrimination when it comes to the use of bail schedules. But what we also learned is that the remedy is a procedural one, that really judges need to get involved and set these bails and make sure that the excessive bail clauses and the rights to bail by sufficient surety in those states are applied to protect the defendants' rights to be free from unnecessary preventative detention and pretrial incarceration. Obviously, what we also learned is there's no absolute right to an affordable bail in the United States, that if a bail is otherwise not excessive, it may continue to serve to detain under these precedents. So at the end of the day, I think there's been improvements in the system of procedural due process in the setting of bail. There's been calling into questions whether bail schedules are effective and efficient. We think they are, but we think jurisdictions who are going to use them need to, you know, take a serious look at the procedures they have in place. And we think the Fifth Circuit injunction offers you a simple pathway to do it. Small cities like Ascension Parish, Louisiana, Dothan, Alabama, they're able to solve this problem in a matter of days. It shouldn't be that complicated. We'd be glad to help. Thanks again for listening to our series, 2021, an update on bail reform. Good day.